Can you change custody orders in Pennsylvania? If you already have a custody order in Pennsylvania, you might be wondering, can I change it? What if the schedule changes or my child's needs change? The answer is yes. Custody orders are always modifiable, but the process depends on why you're asking and what's in the best interest of the child. In Pennsylvania, custody orders are never set in stone. The law allows modifications anytime circumstances change. But the court's guiding principle is always the same: what's in the best interest of the child. Here are some of the most common reasons parents see custody change. When you can change custody: parent relocation, major schedule changes, child's needs change, safety concerns, order violations, relocation or moving. If one parent wants to move, whether it's across town or across state lines, that can make the old schedule impossible. Moves for a new job, remarriage, or to be closer to family often triggers a custody review. Work schedule changes. If your job hours shift, for example, you start working overnights, weekends, or long shifts, the old custody plan may no longer work and the court can adjust it. Child's needs evolve. As kids get older, their school, sports, or medical needs change. A schedule that worked for a toddler may not fit a teenager with extracurriculars and a demanding school routine. Safety concerns. If there are signs of neglect, abuse, substance abuse, or dangerous living conditions, the court takes these concerns very seriously and will view custody immediately. Violations of the order. If one parent constantly shows up late, withholds the child, or refuses to follow the existing order, you can go back to court to enforce or change the arrangement. When you can't change custody: just disliking the schedule. For convenience or preference alone, no major changes in circumstance. To punish or harass the other parent, if change disrupts stability without benefit. But not every reason is enough. The court usually won't change custody just because one parent doesn't like the schedule or because it would be more convenient. If there hasn't been a major change in circumstance, the courts will likely stay out of it. And if a parent uses the court system to harass the other parent or tries to change custody in a way that disrupts a child's stability without clear benefit, the judge may deny the request at all. In all these cases, the court will look at all evidence and ask, does this change serve the best interests of the child? If the answer is yes, the court order can be modified. To change custody, you must file a petition to modify with the court. That's the official way to ask for a change. Without it, your custody order stays exactly as it is. Once your petition is filed, the judge may schedule a custody conference first. That's a chance to sit down with a conciliator or master to see if you and the other parent can agree on new terms without a full hearing. If you can agree, the court will approve it and make it official. If you can't agree, the case moves to a hearing before a judge. Both parents can be present and present evidence, bring witnesses, and explain why a change is needed or not needed. The court will then review the full list of custody factors, including the child's stability and routine, like school, activities, and home life, relationship with parents, siblings, and extended family, each parent's ability to provide care, including work schedules and support systems, the child's ties to their community, friends, and school environment, and in some cases, the child's own preference, depending on their age and maturity, can be taken into account. The court makes it clear, the question is never, what do the parents want? The only question is, what is in the best interest of the child? Every decision, every factor is filtered through that standard. If both parents agree on the change, it's usually simple and straightforward. You can submit the new agreement to the court for approval. If you don't agree, the judge decides after hearing evidence. That can include testimony, documents, witnesses, and sometimes even input from the child, depending on their age and maturity. If a child is in immediate danger, you can file for an emergency custody order. The court will act quickly to protect the child and then hold a hearing to determine long-term arrangements. Parents often make mistakes that hurt their credibility in custody cases, like trying to change custody without filing with the court. Verbal agreements may feel convenient, but they're not enforceable. If the other parent changes their mind, you have no legal protection. Withholding the child from the other parent without a court order. Even if you believe you're protecting your child, the court may view this as interfering with the custody rights. This can actually backfire on you and reduce your custody time. Failing to document changes in circumstance. If your work schedule changes, your child is struggling at school, or there are safety concerns, you need to keep records. Emails from teachers, medical notes, or proof of job shifts. Without that documentation, it becomes your word against the other parents. And we know how that goes. Waiting too long to act. If your custody order isn't working, every month you wait makes it look like the arrangement is good enough. Judges often value stability, so the sooner you file, the stronger your case for change. If you believe your custody order no longer works, the best step is to talk to an experienced custody attorney. They can help you file the right paperwork, gather evidence, and present your case to the judge. At Petrelli Previtera, our attorneys handle custody modifications every single day. We know how stressful these cases can be, and we know what judges are looking for. We'll walk you through the process, build the strongest case possible, and stand beside you in court to fight for a custody plan that actually works for your family. At Petrelli Previtera, we've helped thousands of Pennsylvania families modify custody orders to fit their changing lives. If your order no longer works for you or your child, call us today. We'll guide you through the process and fight for the arrangement that protects your child's future.